Good morning, everybody, and welcome to the Maryland Apex Accelerator outreach event today, training rather. We're delighted to have you join us. I'm your host, Yasmin Razak, and I'm the Marketing and Training Coordinator. Today, the webinar topic is something that a lot of people have been asking us about, so we're delighted to be able to help you out today. It is navigating uncertainty, and it will be about the recent changes in the federal contracting landscape. And it is led by Matthew Schoonover, who is the founder and managing member of Schoonover and Moriarty LLC, which is a law firm dedicated to serving federal government contractors. We'll get started shortly, and there will be lots of opportunity for you to ask Matthew your questions by typing them in the chat on your screen. And we will try and get through as many of them through the next hour as we can. As always, this is being recorded and a copy of the slides will be sent to you after the event. So you don't have to worry about taking notes. A little bit about Maryland Apex Accelerator. It's our mission to help Maryland businesses to compete in federal, state, and local government procurement processes. Our services are no cost to you. So if you need assistance, please go to our website, marylandapex.org, register, and a counselor will be able to assist you within the next 30 business days. Okay, well, that's enough for me. Good morning, Matthew. The floor is yours.
Good morning. How is everybody doing today? It's a pleasure to join my friends in Maryland for, yes, a very needed discussion on some of the changes that we've seen in the federal contracting landscape. And before the presentation started this morning, Yasmin and I were talking a little bit, and she had mentioned that some of the Apex clients were asking questions that they just weren't sure the answers to. And I said, you know what? I'm getting a lot of clients that are asking me questions I'm not sure the answer to either, because there's just so much that is changing and so much that is moving now. So we're going to take a little bit of time today just to kind of talk about some of the major changes that we've seen over the last 6 months or so. And also some things that in our practice we have seen that can really benefit small business contractors as they're continuing to work with the federal government. Sorry, I'm having an issue getting my slides to move here. 1 second. Oh, there it is. All right. Well, the point of this slide is not to show you my face, but rather just to tell you that today's presentation is not supposed to be legal advice. If you do have particular questions, certainly I'm happy to answer general questions today. If there are particular questions, we would recommend that you speak with either Yasmin and her team at the Apex or a government contracts attorney about those, because obviously the devil's going to be in the details as how some of these changes might affect your business. I also wanted to point out that our firm runs a legal blog. Everybody loves a good legal blog, right? But we blog about a lot of these changes and issues as they affect small business contractors on govconbrief.com. So if you haven't checked out GovConBrief yet, I would certainly encourage you to do so. We try and really only put out some of the most pertinent updates for contractors not to overwhelm people. So with that, just kind of a brief overview of what we'll talk about here today. As I mentioned, we're gonna focus first on some of the major changes that we've seen in the federal contracting landscape, and certainly there have been several changes that we're following. There's been a lot of minor changes as well. And I think we'll focus less on those today, but certainly some of the, instead focus on some of the major changes. We'll also talk about a major topic that has been more and more important lately, certainly in the area of DOGE and canceled or terminated contracts. What happens if your contract is terminated for convenience? What are some of the strategies that that you can employ to make sure that you're making yourself whole. We'll also talk a little bit about tariffs and, not so much, the lay of the land, because quite frankly, I'm not sure what the lay of the land when it comes to tariffs are. Who's being tariffed in what amount? I think is a little bit of a moving target. But we are going to talk about a few FAR provisions that may be helpful if your business is impacted by tariffs. And then finally, we'll conclude by talking about a few strategies that we have seen be successful in helping make sure that small businesses are staying afloat of all of the changes that are going on. So with that, we'll start by talking about some of the major changes that we've seen here in 2025. And I wanted to kind of start with one of the bigger changes, the one that's potentially the most impactful, and that is President Trump's Executive Order 14275, which essentially requires the government to overhaul the Federal Acquisition Regulations, the FAR. That is, if you're familiar with the FAR, it is the rule book that all agencies need to follow when they are procuring goods and services on behalf of the federal government. It essentially sets the rules that they need to follow. And the FAR is as you might imagine, very voluminous. It's kind of like a phone book in its thickness. But one of President Trump's early executive orders required the government essentially to redo the FAR, to really limit those regulations to those provisions that are required by statute, which really isn't a whole lot. And so what the essentially the executive order is doing is it's requiring the FAR Council to really pare down the regulations themselves. But then also what they're doing is they're working on as I'm forgetting the exact termination, but it's essentially a guidebook that includes what will be all of the other FAR provisions that they've taken out that indicates how things should operate. So it may not end up being a little bit of too much of a change, depending on how that guidebook is interpreted, if it has the force of regulations, or if it's really just something that the agency should follow but isn't obligated to follow. We'll really kind of see in the future here what this overhaul looks like and what its impact will be. But I will say that the FAR has been the product of agency note and comment. It's really something that agencies go in and take a lot of effort in putting together. The FAR Council takes a great deal of time in putting provisions together, and then puts those out for public note and comment, where folks can weigh in on those. And then once the FAR is kind of codified, then it's really the subject of interpretation, not only through the Government Accountability Office through bid protest, but also from the Court of Federal Claims as well. So it's really something that we've seen develop almost as its own body of law. And it'll be interesting to see here in the future what this overhaul does to that and how these new provisions should be interpreted compared to how they once were interpreted. This is an ongoing process. Right now, the government has reworked several FAR parts, including some fairly major provisions, things like FAR Parts 6 and 10, which deal with competition and market research requirements, FAR Parts 31 and FAR Parts 43, which deal with contract modifications. But we've seen some kind of hints as to how this will be interpreted moving forward. When it comes to FAR Part 6 and FAR Part 10 in particular, there is some concern for how wedded the government will be to some of these small business requirements that were once in the FAR. Those have been stripped out, at least so far, of FAR Part 10. And so as certainly as we see the rewrites to FAR Part 19, which is the small business programs provision in the FAR, it'll be very interesting to see what some of those requirements are moving forward. We do expect the remainder of the FAR to be overhauled as it is by the end of September. I believe the actual deadline from the executive order is mid-October, but last we heard the FAR Council is trying to get that out sooner than that. So certainly, as particularly FAR Parts 15 and FAR Parts 19 are reworked, take a look at GovCon brief, and we will keep an eye on those and update people what those latest provisions look like and some of the implications from those rewrites. We've also seen some changes and likely are going to see some continued changes regarding President Trump's executive order to essentially consolidate procurements, and Executive Order 240, excuse me, generally for common goods and services that are procured by the federal government requires those provisions to be made by GSA, the General Services Administration. GSA runs a lot of acquisitions on behalf of the federal government. They also run a lot of the shared services. They're generally the federal government's landlord in a lot of cases. But essentially, this executive order is designed to consolidate procurements, particularly of common goods and services through GSA. We're still seeing how this is working out under federal agencies, but we are noticing some of the early changes when it comes to some of the large IDIQ contracts or GWAC vehicles, government-wide acquisition contracts that the federal government uses, particularly under existing GWACs. The General Services Administration needs to be made an executive agent under those contracts, so really it can be in charge of purchasing under them. And so we'll see continued changes to that. We're also seeing, quite frankly, some acquisitions being canceled. First Source 3 is a major example there, where this is an IT vehicle that the government had through the Department of Defense, and this was eliminated or canceled in favor of some of the other acquisition vehicles that are out there. And so certainly, as you're taking a look or maybe bidding on some of these opportunities, particularly as it looks for IDIQ or GWAC vehicles, really take a look at who is procuring those and giving some thought to what is the long-term viability of those. We also think it's important for businesses who maybe aren't on GSA's multiple award schedule or the federal supply schedule, as it may be, to take a look at doing that. If you do sell some items to the federal government, some goods and services through the federal government, really we might see schedules being used more and more to procure those goods and services by the federal government as they are consolidated under GSA. Certainly, we have also seen, and this was obviously very early on in the Trump administration, but there was an early and kind of frantic focus to remove instances of diversity, equity, and inclusion from the federal government, and we saw a bevy of executive orders that were designed at doing just that. Those executive orders, some of them are listed here on the screen, but really what those are designed to do in the Trump administration's mind is restore merit-based hiring or merit-based awarding practices to the federal government. We have seen changes to what is required by federal contractors when it comes to executive orders relating to affirmative action requirements. And so there have been some changes as it relates to what federal contractors are actually required to have in the way of policies and procedures as well. And so certainly we recommend that companies take a look at their policies that are in place to make sure that they are aligned with some of these latest executive orders and some of these latest requirements. As part of these bevy of executive orders, one of the executive orders that we did see revoked was a binary executive order that required the federal government or increased the goal for contracting to socially disadvantaged businesses. That goal under the Biden administration was increased from 5% to 15%. And with the rescission of that executive order, it is reverted back down to the baseline of 5%. So if you're an 8A contractor, if you're an SDB, know that those goals have changed a little bit for you by virtue of the rescission of some of these executive orders. And with that, I think that's a decent segue into one of the main questions that we've received over the last 6 months, and that is, what are some of the long-term viability or long-term prospects for some of these socioeconomic programs, particularly the 8A program and the Woman-Owned Small Business Program. The 8A program, if you're not familiar with the program, it's really a program that is designed to remedy instances of past discrimination, where in order to qualify for the program, your business has to be owned and controlled by at least one individual who is both socially and economically disadvantaged. And a lot of times under the program, that social and economic disadvantage is demonstrated by the owner's inclusion in one or more racial or ethnic groups that has historically been discriminated against in American history. And so the 8A program is really designed to help lift up some of these businesses, to help remedy some of these past instances of discrimination. Similarly, the Woman-Owned Small Business Program is a program that is designed to give women kind of an equal playing field in some industries that women have historically been discriminated against, largely the construction industries, but also other industries as well. And under each program, the government can set aside or reserve contracts for businesses that qualify. And so it's really a way for these businesses to get, I won't even say a leg up, I'll say an even playing field when it comes to federal government contracts. And so we have seen, as the Trump administration has moved away from what it calls DEI and into more merits-based awards, is there a long-term commitment to the 8A and WOSB programs? And the best answer I have is, I hope so. Each of those programs is statutory, so I do think it would be difficult for the administration, or for any administration, I should say, to abandon them outright. But we have seen constitutional challenges to these programs in the past, and so one of the things that I fear is whether we see such challenges in the future and don't have a defense by or full-throated defense by the Department of Justice in those instances. So that's one thing that we are watching. We're also watching, particularly as it relates to the 8A program, a recent announcement that SBA is now undertaking what they call a full-scale audit of the 8A program. And they're really going back, they say 15 years, but it could be even more than that, reviewing high dollar and limited competition contracts for instances of what they say could be fraud or bribery within the program. And justifying this, the government has cited to a couple of examples where individuals were convicted of fraud or bribery relating to the 8A program, and said, the existence of these instances compels us to take a deep look into the program. That's all fine and good. I think, looking at these programs to make sure that they're running correctly, to make sure that they're running efficiently is, I think, a good thing. My personal concern is that, again, the administration might use this as a way to be less supportive of the 8A program itself. And although the program is statutory, I'll note that the statute does give the administration some discretion on when it will use the program. That is, right at the outset of the 8A statute, it says, "It shall be the duty of the administration, and it is hereby empowered, whenever it determines such action is necessary and appropriate, essentially to use the 8A program, for the benefit of these contractors." And so what I'm concerned with is this going to be a way that perhaps the administration can say it is no longer necessary or no longer appropriate to use the 8A program? That would be extreme, but it's nonetheless something that we are concerned about, and so we will continue to take a look at it. By the way, I will say, just one of the things that kind of continually irks me is the notion of waste, fraud, and abuse in these government contracting programs. Yes, I certainly think that in some instances there is waste or there are efficiencies that should be captured. But I have a concern where the government seems to think that whenever something bad happens or something that shouldn't happen happens, excuse me, it's necessarily indicative of fraud. Fraud, to me, as a lawyer, is a word that has a very specific connotation. Just because something happens and somebody was wrong doesn't necessarily mean that it was done with a fraudulent or a criminal intent. And so when I look at these things, I oftentimes think, yes, we're talking about billions of dollars worth of federal government contracts. And whenever we are, there's always going to be instances where somebody on the outside could look at it and say, well, should that money have been spent in the way that it was? Or with the benefit of hindsight, would we have awarded to this company? There's always room for those questions. But me personally, I just, it bothers me when the government immediately jumps to fraud. And I've seen it in my practice, and I've had to convince the government on times where it's, again, just because something is wrong doesn't necessarily mean that it is fraud. So anyway, that's the Matt Schoonover soapbox for today when it comes to how the government is kind of viewing some of these issues. Another executive order that we've seen that may impact the federal contractors is the rescission of executive orders that increased the minimum wage for contractor employees that are working on federal government contracts. At one point, that minimum wage was as high as $17.75. I believe, though, that with the rescission of these executive orders, it is now back down to the $13 range as it was under the Obama administration. I will note, just when it comes to paying contractor workforce, there are still going to be a lot of rules and regulations that apply. Those include state minimum wage laws. Obviously, you want to make sure that you are complying with whatever state minimum wage law is in place where your workers are working. Also, if there's the Service Contract Act or the Davis-Bacon Act, sometimes there are prevailing wages that are even higher than the minimum wage. So the moral of the story is you want to know what the various minimum wages are that apply to your workforce, and make sure that you're meeting, whatever the highest number of that is in there. So you're complying with whatever the highest minimum wage is for that particular workforce. Sorry, I'm having an issue again. So with this slide kind of sums up where we've been for the first 6 months. Certainly when the Trump administration took over, in January and February and March, we were seeing a lot of executive orders and a lot of uncertainty as it related to how the administration was going to procure items, and not only that, for some of the items that it had already procured. We saw issues with Doge and certainly some slowing in the contract or in the awarding of contracts with the contract workforce. We've seen some termination of contracts, and we'll talk more about that in just 1 minute. And we've also seen, the contracting workforce face upheaval. And if you work with the federal government, I know that you felt that trickle effect, where it's probably harder to get somebody at the agency on the phone. Maybe your contracting officer has changed, or your COR has changed, or something has changed that's made things more difficult for you. And we have certainly seen that. And the thing I will say is those folks that remain inside the federal government are certainly dealing with a lot. The stacks of paper on their desks have only gotten higher. And so, I think they're doing the best that they can, but at the same time, from the contractor perspective, these delays are certainly causing some effects when it comes to performance. So, with that, I did want to transition to terminations for convenience and what contractors can do if the government decides one day to terminate their contract for convenience. And in those cases, I think it's worth noting that all's not lost for a contractor. Yes, the government has the right to terminate contracts for convenience. And by the way, that's an extraordinary right. Usually in contract law, one party doesn't have the ability to wake up in the morning and say, I no longer want to be bound by this contract, so I have the power, the unilateral power, just to end this contract. That's a pretty extreme right, and for one of the reasons why I say it's good to be king, it's good to be the federal government, because you can have that ability to do that. But from that ability, there also comes some responsibilities from the federal government. And essentially, those responsibilities are to make the contractor whole for what it has incurred so far in its performance. If the government terminates a contract for its convenience, that contractor, in theory, should not be left holding the bag for the charges associated with that performance. That is entirely different, by the way, from a termination for cause or a termination for default. Those are the bad terminations that contractors want to avoid really by any means possible. In a contract for, or a termination for default or a termination for cause, that's where the government has said, contractor, you're not meeting your obligations under this, and we're exercising our right to get out of this contract because you're not doing what we contracted with you to do. You're not meeting your end of the bargain. You're breaching our contract. So as a result of that, you are not entitled, contractor, to any of the costs associated with your performance. Moreover, you, contractor, may be required to reimburse the government for any re-procurement costs associated with that. So terminations for default or for cause, however they may be characterized depending on your contract type, are certainly very bad and something that you want to avoid. A termination for convenience, again, is where the government just says, for one reason or another, it no longer needs this good or service, or it no longer wants to be under this contract. And in those cases, like I said, it's really through no fault of the contractor, and so the contractor should be made whole for those. If you do receive a termination for convenience notice, there are a few things that you should immediately do. First, verify the termination for convenience with the contracting officer. Only the contracting officer has the ability to terminate the government's contract. And I know a lot of times these may come from the COR or somebody else under the project. If it does not come directly from the contracting officer, I always encourage a contractor to forward it to the CO and to say, just wanted to confirm this T for C is in your name, or to confirm from you, our contract is terminated for convenience. That should be your first step. Verify it with the contracting officer. While you're doing that, I also recommend that you review the applicable FAR section. There should be a FAR section that's cited in the termination for convenience letter, and review that provision to start understanding what your rights and obligations are under that termination for convenience. You're also going to want to, usually that termination for convenience notice is going to have some instructions for you, like immediately ceasing all work and instructing your subcontractors to stop work. You're going to want to follow those in writing, make sure you're documenting those with the agency and with any subcontractor under there. As part of that, you want to make sure, and this is just kind of an aside. If you are a prime contractor under a federal government contract, you want to make sure that your agreement with any subcontractors has the ability to terminate that contract for convenience. The government has the right to terminate your contract for convenience as the prime contractor. So as the prime contractor with subcontractors, you want to make sure that you have that right with your subcontractors too. That can save some heartache and some money moving forward as well. But then the real work kind of starts when it comes to termination, and that's where we start to document our costs associated with that termination. And there are going to be some efforts that a contractor needs to do to start mitigating some of its costs under the contract, because really it's only those unmitigatable costs that you've incurred that you'll be entitled to. But we also want to start documenting, to the extent we don't already, the time being spent internally at the contractor's office on termination related activities, because that time, that effort should be compensable by the federal government as well. So you want to make sure that you're documenting all of your efforts and the time that it's taking to actually do those under the contract. The goal, as I mentioned, under a termination for convenience is essentially to make the contractor whole. Their fixed price contract becomes, in effect, a cost reimbursable contract, where the contractor should be paid for the costs it incurs associated with its performance under the contract. You're going to do that as a contractor through what's called the termination settlement proposal. And the FAR has a couple of different termination settlement proposals to follow, but these are in essence a negotiation between the government and the prime contractor when it comes to those termination settlement costs. And you're going to have to support your TSP with internal data and records demonstrating that these costs are appropriate. As part of this, a prime contractor is expected to settle its subcontractor claims as well. So if you're a prime contractor, you want to be working with your subcontractors to make sure you're getting any of their termination costs. If you are a subcontractor, you want to make sure that you are working with your prime contractor so that your costs are claimed, and make sure early on, once that prime contractor, if you're a subcontractor, gives you notice of termination, you need to tell them, hey, we're going to have some costs associated with this that you'll need to include in your termination for convenience settlement proposal as well. You want to put them on notice that you're going to have some costs associated too, so that they know that they should come to you and make sure that those are included in their TSP. Finally, termination settlement proposals do have pretty strict deadlines. So when you're reviewing the FAR, when you're reviewing your obligations under those, you want to make sure that you know what that termination settlement proposal deadline is. Sometimes it's a year after termination that you have to submit those. Other times it's much shorter than that. And so you want to know what those deadlines are and comply with them, and importantly, keep the contracting officer abreast of what's going on as well. When we look at the type of costs that can be claimed, I mentioned that really the goal is to make you whole. And so you're going to recover your costs for work performed up to the point of termination. You know, if these are unmitigatable costs. So if you have purchased equipment or supplies that cannot be sold or reused under a different contract, you may be able to claim those. If there's employee-related costs associated with that, including, I should say, any costs associated with terminating employees who are no longer needed because of a contract termination, those should be documented and claimed as well. Additionally, if you have performed work that has been accepted by the federal government, you are entitled to recover your profits for that performed and accepted work. You're generally not allowed to recover profits moving forward after that termination, but if you have performed work that has been accepted by the government, you should be able to recover your reasonable profit associated with that work. What is reasonable profit? Well, really depends on the circumstances of your contract. You know, you're gonna factors to consider are really kind of the difficulty of the work and the efficiency of the contractor in performing that work. If there's kind of an industry standard when it comes to profit, you know, we're going to look at those as well. What is the profit that the contractor would have earned if the contract hadn't been terminated? And maybe there's a way to kind of demonstrate that, well, you know, we performed a third of the contract, and so, you know, maybe a reasonable profit would be a third of what our profit would have been had this contract not have been terminated. You know, what did the contractor contemplate at the time of the award as well? These are all considerations that they're going to be going into to determining whether your claimed profit for completed work is in fact reasonable. Just know that you're going to need to justify that claimed profit to the government, and that could be one of those areas that they view is ripe for negotiation. Any continuing costs that are associated with the contract after its termination, you know, if you're trying to wind down contract costs, if you now have idle facility or capacity issues that are associated with the contract termination, you may be able to recover those. I mentioned employee costs. If there's costs associated with reassignment of employees or even letting those employees go, maybe some employees are needed still to kind of wind up efforts. Maybe you've got some folks who are trying to sell equipment or sell facilities that are out there to mitigate some of those costs. If you have ongoing rent, or if there's any kind of unabsorbed overhead or that type of stuff, you may be entitled to those. So really, if you do have a contract that is terminated, you want to make sure that you're working at the outset, like I said, to document these costs moving forward. And we do recommend, in some cases, that outside termination consultants be brought in, cost consultants be brought in to help document and claim all of the costs that you are entitled to as a result of the termination for your contract. The termination settlement proposal is pretty much a negotiation. You know, it's going to be negotiated by the government and the contractor. And so you want to make sure as a contractor that you are supporting whatever it is you are asking for through contemporaneous records and documents, because at that point it gets harder for the government to kind of negotiate those costs down, because you can demonstrate what the actual costs associated with the termination are. And just know that, at the end of the day, the burden's going to be on the contractor to demonstrate what appropriate termination settlement costs will be. So the key, as I've said several times, is the sufficiency of the documentation by the contractor. Really, everything should be done in writing once you receive that termination settlement proposal. You need to document the time spent. You need to document efforts that are associated with mitigating costs. And if you can't mitigate costs, you need to be able to explain, here's what we've done to try. And so really, as part of this too, I know this sounds like a lot of work, but the good news is that contractors can recover reasonable settlement expenses associated with the termination of their contract. This includes the costs associated with preparing the termination settlement proposals and settling with subcontractors. This also includes, I'll note, reasonable professional services. So if there's accounting or legal services that you need, oftentimes those costs can be claimed as part of a termination settlement proposal as well. So we've really kind of seen terminations for convenience. I'll say they were more common within the first few months of the Trump administration, really when DOGE was kind of moving hot and heavy in some of those initial months. I will say from our experience, anecdotally lately, it seems like that's subsided a little bit. But I will say that there are still some pressures internally with the government to save costs and to cut costs where appropriate. And so sometimes it believes that it's in its best interest to terminate a contract for convenience. Contracts that are that maybe had to do more with DEI, consulting contracts, those type of things, I think were more susceptible to being terminated for convenience than perhaps other contracts might have been. But nonetheless, know that as a contractor, if the government does decide to terminate your contract for convenience, you do have rights associated with that termination, and you may be able to recover a decent amount of money associated with that. The next thing I wanted to talk about is kind of the uncertainty that we've seen when it comes to tariffs. I know as of right now, well, I shouldn't say I know, I believe as of right now, there's a 10% tariff universal applied to everybody else in the world. And there are other rates that are higher, maybe higher, depending on the good that is being imported or the country that it's being imported from. And so one of the things that we have seen or heard from contractors is, well, how do I deal with the costs of tariffs under my contract? That is, when I entered into this contract with the government, or when I bid this work, these tariffs weren't in place. And now the costs associated with my performance have been made that much higher because folks need to offset their tariff-related costs. I don't have a silver bullet answer for you, but there are a few FAR provisions that may be helpful for you when it comes to claiming those increased costs associated with tariffs. Really, the best option might be FAR 52229-3. And this provision allows for an equitable adjustment in the contract value for any federal excise tax or duty imposed after a contract award. And so really here, what we're going to have to show is this is the result of, the increase in costs or the result of any federal excise tax or duty imposed by the government after the contract award. In that case, as I mentioned, you may be entitled to an equitable adjustment associated with those tariff-related or excise tax or duty-related costs. I'm not an economist. I can't tell you for sure whether a tariff qualifies definitionally as in a federal excise tax or duty. I would assume it does, but certainly that's going to be something that needs to be made clear in order to claim under that. I also encourage contractors, particularly under fixed price contracts, to see if their contracting officers would be willing to incorporate FAR provision 52216-2 or -4 as appropriate. These are essentially EPA clauses, economic price adjustment clauses, where prices may be adjusted up or down depending on actual cost treatments during the contract. If actual costs, I think the minimum threshold is 10%. If they're 10% higher or 10% lower than the contract costs may be adjusted there. This isn't a common clause that is used, but it is one that, at least for now, remains in the FAR that contracting officers may be able to avail themselves of, or contractors may be able to avail themselves of if it's incorporated in the contract. And so what I tell folks is, at the outset, it doesn't hurt to ask the contracting officer to include this provision in a contract before you bid. Worst they're going to say is no. And at that point, you would know, okay, well, this really is a fixed price contract, and I need to make sure that my bid is incorporating all of those issues that may come out as a result of tariffs or other issues. FAR 52243-4 is another provision that may be beneficial. This is a provision that allows for increased costs if there are any contract changes associated with the work. That may be difficult to show here in the case of a tariff. That is, it may not be an actual change under the contract, but nonetheless, it's something that you might want to consider. There's another provision that may be worthwhile in considering. That is FAR 52249-14, which allows a contractor to claim additional time under the contract for excusable delays, which include any acts of the government in either its sovereign or contractual capacity, and any freight embargoes, among other things. There are other things that may trigger the excusable delay provision, but if the act of the government in its sovereign capacity includes imposing tariffs, and if those tariffs mean that you can't perform under your contract, then you may be entitled to an excusable delay. You're not entitled to money under this provision, but additional time to perform under this. So that's kind of a tricky needle to thread. I think I'm mixing idioms. But nonetheless, it could give a contractor some ability to tell the government, hey, we need more time to deal with this, to see what the impact of tariffs is going to be on this contract. Again, kind of tricky to do, but could be an arrow in your quiver, so to speak, to use if you are seeing issues. Finally, we've got a few minutes left. I did want to discuss a few possible strategies for contractors as things continue to evolve, and as we're seeing things continue to change in the federal contracting world. The first is, of course, you want to stay abreast of any issues that are out there when it comes to federal government contracting. Follow the news as it relates to federal contracting. I'm not saying doom scroll, but just be aware of any changes that may be going on out there. Make sure you're communicating with your Apex accelerator, because they're great resources for changes as they are being discussed by the federal government. Other contracting advocacy groups are out there that you may be involved in or may find value in from working with, the Society of American Military Engineers, the National Association for Contract Management, some of these other entities. Maybe they are veteran contracting focused entities, or women contracting entities that are out there. certainly stay in touch with other advocacy groups because they do a good job, particularly as it relates to how some of these changes may affect their core constituencies. Other resources that are out there, I mentioned GovCon Brief as one resource. There are other great legal blogs that are out there too. I use them as education for me on a daily basis, just because it is hard to keep track of all of the changes that are out there affecting government contractors. And so you want to make sure that you're keeping aware of all of the news. I also think it's more important than ever to maintain good communication with your contracting officer, particularly in writing. Ask the contracting officer if there's anything you can do to help. We were at least certainly at the start of the Trump administration recommending to contractors that they take the initiative and kind of put together a half page or a one-page document that they could provide to the contractor, or excuse me, contracting officer, that explains the value of their contract and why the government should keep it, and providing that to the contracting officer. And so the contracting officer can have on file in case anybody comes knocking on their door to say, hey, tell me about these contracts. That might not be a bad idea for contractors to have, but certainly make sure that you are maintaining communication with your contracting officer so that you can know of any changes that might be in the works, and also so that you can communicate any issues to them as well, hopefully before they become anything too major under the contract. Finally, adapting is the name of the game here. We've seen a lot of small businesses have to really change focus and make sure that their business is best positioned to maintain and to earn contracts moving forward. And that can be a tough thing to do, particularly where we've seen the government kind of shift their priorities. Now flexibility is the name of the game. And so, how are contractors maintaining an open supply chain with some of the headwinds that maybe are being imposed on them through tariffs or other issues that are out there? How are contractors maximizing the use of technology responsibly when it comes to federal government contracts? We've seen that when it comes to AI and how AI is going to impact contractors. And so know that there are kind of these issues that are out there percolating that you need to stay abreast of. Finally, as I mentioned, be proactive. Take the initiative to explain to the contracting officer the importance of your contract and how it fits with the administration's priorities. Advocate for your contract, and more importantly, help the agency advocate for your contract as well, particularly internally. I encourage folks to take a look at GSA schedules if they haven't already, or if they're not part of their contracting repertoire, so to speak. But particularly as we are seeing contracts be consolidated under GSA, having a GSA schedule may help give you a leg up in competition. And finally, this advice I think is more prudent than ever. Develop strong teaming relationships with other companies. We are seeing and we continue to see contracts be consolidated into larger and larger vehicles, and some uncertainty as to how those will be procured. But if you can develop a team of good contractors with good past performance, I think you've already set kind of the standard there for bidding on some of these contracts. Consider mentor-protege relationships. If you are a small business, consider working with a large business protege who has experience and capabilities that can help you grow your business and work with the federal government. Consider joint ventures. If you're in a mentor-protege relationship, I think a mentor-protege joint venture is oftentimes kind of the most competitive way you can bid under a contract, because a lot of times you're able to leverage not only your small business size, but also the capabilities and the experience of your large business venture in those cases. And they've been so successful, in fact, that we've seen the SBA start to question whether it should limit the ability of mentor proteges to form joint ventures for some of these awards. That hasn't happened yet. But certainly, I think the proof is in the pudding when it comes to the success of mentor protege joint ventures and bidding on some of these contract opportunities. So with that, I know we've got about 5 minutes left for questions. I did want to thank everybody for their time and attention today. As I think, or I hope that the presentation has made clear, we have had a lot of changes, but there are still some ways for small businesses to remain competitive in kind of this changing marketplace. My contact information is on the screen. Please feel free to reach out by phone, by email, anytime. We're happy to answer any questions that you might have. So with that, Yasmin, I think I'll turn to you and see if there's anything in the chat that I might be able to answer.
Thank you so much, Matthew. That was great as usual. And yeah, I think you pretty much answered the questions already as you went through the presentation. But if there's anything you'd like Matthew to go over again, please type in the chat box. I've posted links to some of the resources you can use on our website, all our previous recordings. We even have a GovCon roadmap for beginners if you don't know where to start. And you can sign up for Matthew's next class with us, which is going to be in September. And it's going to be about debriefings and bid protests. So we're looking forward to that.
It'll be a fun one.
Sorry?
I said that'll be a fun one.
Yeah, definitely.
Everybody loves a good bid protest.
Yes, definitely. Yeah, that's pretty much it. Doesn't seem like there's any final questions that have come in. So I think you covered it all. They're just saying thank you so much, Matthew. So yeah, we definitely appreciate that. The recording is going to be available later today on our YouTube channel. And I believe Matthew's going to send me these slides so I can share them. So yeah, thank you, Matthew, for excellent presentation. Thank you, everybody, for participating today. And we hope to see you at a future Apex webinar. Take care. Bye-bye.
Have a great day.